All right. Well, welcome, Alan. It's so nice to have you. Welcome to everybody who's listening today. My name is Stuart Teicher, and this is my podcast, which is called Legal Ethics is Cool. And I'm desperately trying to make that a reality. That legal legal ethics should be as seen as cool. We'll see. If maybe it'll just be a few of us who really feel that way. But I'm really excited to have. I'm doing this part of most of my podcast is going to be dedicated to what I call the DC and GC project, the DC and GC project, where I'm going to try to interview as many disciplinary counsel and general counsel for both states and law firms as possible, and talk to people about what they think and that sort of thing. And my very first guest in that regard is, well, Alan, why don't you introduce yourself?
Sure. Thank you, Stuart. I'm Alan Pratzel. I'm the Chief Disciplinary Counsel in the state of Missouri under an appointment from the Supreme Court of Missouri.
Wonderful. Now, Alan, I didn't give you the questions that I was going to ask you today, and I'd like to say that I did that purposefully and it was some grand plan that I had. But I don't think it would be wise to start a conversation with the Office of Disciplinary Counsel by lying. The truth is my first time we're doing this, and I didn't think about it. So
Not a problem.
So I thought maybe what I would do is I like to kind of start off with some substance. I want to get to know you and find out how you got to where you are. But maybe I would start with sort of a substantive question to kind of get people listening. And the question I want to ask you is, what do lawyers do that surprise you?
What I would say is this. Some of the things we get, Stuart, in our office are pretty mundane, things that you might expect. Lawyers who are procrastinating, failing to communicate with their clients. What always surprises me are the lawyers who believe that they can get away with commingling, taking money from their clients through their trust account, things like that almost always are going to end up on our radar screen, either through a report from the client themselves or from an overdraft of the trust account, which we are notified directly by the bank holding that trust account. So mishandling client money always surprises me because it's always a serious violation, Stuart. It's generally going to go straight to the character and fitness of that lawyer to hold a law license, and generally those cases, if they involve misappropriation at least, end up in front of our court for possible serious discipline.
And it's not difficult to find out about that stuff, right?
No, it really isn't. I mean, the fact is that there's always going to be a paper trail when there's money that's missing from a trust account. And as I said, in a lot of our cases, those are triggered not because the client knows that something has gone wrong and their money's missing, but because there seems to be a correlation between lawyers who are mishandling intentionally their client's money and being sloppy with their reconciliations of their trust accounts. So there's a very close correlation between lawyers who are engaging in that type of conduct and an overdraft of the trust account. They bounce a check out of the trust account because they've lost track of what money is in there. Well, once that occurs, we get notified by the bank that that's occurred. We open 100% of those files, we audit the trust account, and that paper trail just opens up exactly what's happened. We're able to tell through an audit of the trust account, this trust account, this lawyer has been mishandling the client money and using it for personal expenses or office expenses.
Yeah, it's funny. Every single program I give when I teach CLE, every single one, it doesn't matter what the topic is, and I get a kind of a laugh out of it, but now I think people will see why. I always say there's two things I have to say at every CLE program, regardless of what the title is and what the topic is. And those two things are: don't steal from your trust account and don't sleep with your clients. I think.
Right.
Do you see that one in your office a lot as well?
We get a little bit of both, but the trust account issue is much more significant in terms of how many cases we get, because it is it's the source of most of the complaints we take up to our court, mishandling that trust account money. Now, you should know that not all the cases where there's overdrafts involve misappropriation or commingling. A lot of them are simply negligence on the part of the lawyer. Perhaps they failed to correctly reconcile their trust account. Perhaps they prematurely dispersed the settlement check before the settlement check went through the banking system and became good funds in the trust account. Those are types of issues that we're not going to send up to the court. We're going to try to educate the lawyer so that they know how to handle that trust account, and hopefully we never hear from them again.
Gotcha. Great. So now let's backtrack a little bit and find out a little bit about you. I like to kind of start with something substantive, and now get into your details. Did you always have a passion for attorney discipline like I did?
Absolutely not. In fact, it was almost by happenstance, Stuart, that I became involved in the discipline system. I've been licensed since 1978, worked at a mid-sized law firm in St. Louis, Missouri. In 1985, I was a young partner, and the managing partner at the firm walked into my office one day and said, "We've been asked by the discipline system to volunteer one of our lawyers to work for the system as what's called a special representative, basically a person doing the legwork, assisting with investigations." Stuart, I knew there were ethics rules. I hadn't graduated that long ago. I knew the ethics rules were there. I kind of knew there was a system to enforce those rules, but I knew nothing about the system in Missouri. But when you're asked by the managing partner to do something, I was a litigator at the firm. I said, sure, I'll take that on. And so in 1985, 32 years ago, I became involved in the system as what's called a special representative, assisting with investigations. I became very enthralled, impressed with the system, learning more and more about it, how it works in Missouri. We're somewhat distinctive among the states in terms of how our system works, in that we use practicing lawyers to investigate and make decisions on about 50% of our cases. And so I just became really happy with the system, learning about it, and began doing that work alongside my private practice. I was still litigating for the firm, but doing this work in addition to it, and became more and more involved in the discipline system. Did I ever think it was going to lead to becoming chief counsel? No, never. And in fact, I continued as a special representative until 2007, 22 years, and then this top position opened up, and I was appointed by the Supreme Court to become chief disciplinary counsel. Back in '07, I'm like 55 years old. I'm thinking, well, this is maybe something that I can retire from eventually. I really like doing this. Maybe I'd like to do it full time. By that time, I had moved into a private practice, solo private practice, and was happy doing that, but also really loved the discipline work. And so I just made a decision that I would just take over the top job within the discipline system, leave the private practice, and that's what I've been doing now for 15 years.
So you came in '85, and I'm guessing that must have been sort of when what I call now the new rules just came out, right? I mean, we had the Code of Professional Responsibility, and I guess the ABA gave us the model rules in '83. So did you start working with the model rules in Missouri, or were you still in the old code?
We were still using the DRs,
right.
The canons and DRs, and then I believe Missouri adopted the ABA model code in about late '80s, right around 1990, and we began using what is currently the ABA model code as the model. Now, as with most states, our court adopted the ABA code with some amendments and revisions, and did not adopt everything, but adopted in large part the structure of the current code. That's correct.
What do you feel? Did you like the old one better? Does it?
No. I think the new one, Stuart, it's a great question. The new one, I think, is more clear. It's more structured in the way it's put together. I think it's easier for a lawyer to find the answer to a question. And of course, in Missouri, we have resources. We're an enforcement agency. Our office, what we call the OCDC, the Office of Chief Disciplinary Counsel, is a look-back agency. We enforce past conduct. But we have a sister agency that is a prospective agency, and that person, the Legal Ethics Counsel, gives prospective ethics advice to any lawyer who's wondering about an ethics issue and wants to make sure that they take the right steps to avoid any rule violations. So as an enforcement agency, I found the ABA model code as it currently exists to be much more structured, more clear in terms of the way it's put together for the practicing lawyer and for us.
Yeah, one of the things that I think some people criticized, we're calling it the new code, like it came out last week, although 30 some years 40 years Is it
Right.
40 years? Oh my God, I can't believe 1983 was 40 years ago. It's been a long time since I had my mullet, Alan. I,
And since
you know,
I had my hair out to here.
the one of the things that people criticize when the code we currently use came out is that they pulled out the morality from the code, so to speak, and that it's really just an enforce excuse me, just an enforcement tool. Now, personally, I think that's what we needed at the time. Do you think we need to insert more morality into the code, or is it not practical? What do you think about that?
Yeah, I think that the morals of any given situation, you're right about that. It's really absent from the ABA code right now and from our rules. I mean, there are situations where a lawyer is required to take certain ethical actions for their client that may not be what the public believes to be moral. Now, I do see a shift among some states moving towards including morality in the rules and allowing lawyers to make decisions based on what the moral situation is. You know, we see that sometimes with, in some states with the exceptions to confidentiality, that they're being broadened to take in the moral issues, such as, you know, someone who perhaps was improperly convicted of a crime. They are innocent of the crime. The lawyer knows who did commit the crime. Perhaps it's their client, and allowing them in certain situations to take the moral action that they might not be able to take under the code as it's currently written.
So, I'm sorry, I think I missed what you were saying. Did you say you're starting to see that occur more and more?
I think in some states they are actually including as an additional exception to confidentiality the ability to disclose information of your client when it will result in the release of someone who was improperly and falsely convicted of a crime. And so,
Interesting.
yeah, that to me is a situation where some courts are deciding this is bringing that rule of confidentiality more towards a moral stance than simply an ethics stance.
Yeah, I think for my personal feeling is that I think we're ready for that. You know, I don't think we as a practice were ready for it when this code came out in 83, because I don't think a lot of people, and in the 80s as other states adopted it, you know, I don't think a lot of people took the disciplinary system seriously at that point. I mean, after Watergate, we know how many people were involved, how many really big lawyers were involved in Watergate. And I always joke around when I give my programs how, you know, in My Cousin Vinny, where the judge says to Joe Pesci's character, he wants him to wear a suit instead of the leather jacket, and the next day he comes in and says, "Did not tell you to wear some kind of cloth." And Pesci looks at him and goes, "You were serious about that?" You know, that's kind of like how I see a lot of lawyers back in the early 80s when these codes came out. And I think for a really long time we needed to have that very strong sense of discipline and to a certain extent to take away the lawyer's discretion, especially when it came to confidentiality. But I kind of am happy now. I think that we're ready for a little bit more discretion, and it might help us resolve some of those morally ambiguous situations. I don't know
Yeah, I
if you
tend to
feel the same
agree.
way about it.
I agree.
Yeah. So let me ask you a question. What misconceptions do you think people have about the disciplinary system? You know, lawyers who are out there, what kind of misconceptions do you think they have?
You know, one of the misconceptions I think is that we're out to punish lawyers. When we get a complaint, that we're going to punish the attorney for what they've done, and that never comes into our consideration, Stuart. You know, if we have a mission statement in Missouri, and I think this is true throughout the 50 states among the discipline systems, it's to take whatever actions necessary to protect the public and the integrity of the profession, the bar. And in Missouri, you will find that in any opinion from our court, they always point out that this is what directs our decision in terms of what the appropriate discipline is. We never are out to punish a lawyer. And the fact is that we have tools in our basket that allow us, instead of sanctioning someone or seeking discipline from the court, to actually try to get them back on course through maybe a diversion agreement, where if they are suffering from some sort of disease, disability, whether it's an addiction, depression, whatever the case may be, or simple law practice management needs, that we can actually help them to get the assistance they need. And in our view, it doesn't result in discipline, because if they complete that diversion agreement successfully, we actually dismiss the underlying case where we did find a violation, but the attorney got the help they needed. So I think one of the misconceptions is that we are here simply to hammer lawyers. The fact is that whenever we can, if we can help the lawyer get back on track, to us that fulfills our mission statement. And I will tell you that our diversion agreements over the years, we've had that tool in our basket for about almost 20 years now, and we do yearly analysis of success rates. And the fact is, in terms of recidivism, a successfully completed diversion agreement, in about 70% of the cases, we never hear from that attorney again. So that really says a lot about that ability to help lawyers rather than simply sanction them.
And those diversion agreements, that's basically when a lawyer is accused of minor unethical conduct, right?
Right. A lot of it's law practice management issues. These are really good lawyers when they're in court, perhaps, or negotiating a transaction. They're not the best business people. They don't return phone calls in a timely fashion. They're procrastinators. They're not great business people. They need help with regard to law practice management issues. And you deal with lawyers all the time that are in that situation. And that, to us, is a situation that's just ripe for trying to help that lawyer get back on track and help them become more attentive to their clients, so that they fulfill all their clients' needs, and we never hear from them again. And when we've had those types of situations arise, they've been very successful in terms of not having repeat offenders come before us.
Yeah, I often tell lawyers when I speak to them, I say the quickest way to get into the disciplinary system is to piss off your client.
Yeah,
and I granted I'm a little Jersey there, so that's my
well,
my
and I distinguish between lawyers who are obnoxious and simply are obnoxious towards their clients, because there's no ethics rule that prohibits boorish behavior towards your clients. It's when that becomes a lack of communication or procrastination that we get those complaints. We do get complaints about lawyers who the client will say the lawyer cussed me out and then hung up on me, and I want you to investigate them. Guess what? We reject jurisdiction of those complaints, because that is not an ethics violation. That's more civility and professionalism that's really addressing. That really is not covered by the ABA code.
Yeah, and that's what I end up saying with them also, is that it's that anger usually that causes the complaint, but then you got to make sure that you got to have something actually underneath the complaint that's worthy of investigating. And for me, I think it's that communication that I see most often, because I didn't mention in the beginning that I spent years as one of those, like you did, as one of the full-time lawyer practicing investigators in my home state of New Jersey. And for me, a lot of the places that the matters that I investigated, not all of them, but a lot of them, were lawyers who did something, not communicating, maybe not giving the file back, when a client moved from people, making the client so angry that they ended up bringing the complaint. And then once you get the complaint, you start looking at it. Sometimes you find some stuff that's really significant there.
No, exactly. I mean, we've had situations where the complaint involved the lack of communication, and the client sends in the representation agreement. We look at the representation agreement, and it's got a clause that the retainer fee or advance fee payment is non-refundable. So it just opens up a whole another Pandora's box of issues for that lawyer, because you can't have a non-refundable fee in Missouri and throughout most of the country. There's no such thing as a non-refundable fee. You only keep what you earn and refund what you don't earn. So yeah, those slight minor complaints like communications diligence sometimes open up into much more significant investigations for us.
So I didn't actually intend to ask you about this, but you just mentioned about non-refundable fees, and it's something that fascinates me, because there are a bunch of cases that I've seen in the past where a lawyer takes a flat fee, one that's earned upon receipt, and puts it into their trust account. And it doesn't belong there, right? But I think Missouri has sort of a unique rule in that regard, don't you?
Yeah, so we allow, if it's less than, if you collect an advanced flat fee of less than $2,000, you can actually put that into your operating account, and it's perfectly ethical. Our court just a few years ago, to assist mostly solo and small firm lawyers, Stuart, with the paperwork morass that they get into with their trust accounts, just having to keep paperwork that tracks every transaction. Our court amended our safekeeping property rule, the comments to it, to allow this small amount of an advanced fee payment, non-flat fee, be put into the operating account. Does that mean that it belongs to the lawyer, and if the lawyer doesn't complete the flat fee representation, that there's no refund due? No, that doesn't mean that. In fact, you still owe a refund to the client based on some sort of percentage of the work completed towards the completion of the case, the flat fee representation. So even though it's being allowed to be put in the operating account for paperwork purposes, you still owe a refund. It's still not a non-refund. It's not considered non-refundable. You still owe something back to the client if your representation is terminated before the flat fee representation is concluded.
Right. So where you put the money isn't necessarily tied to whether you can ultimately keep that money if something goes wrong and that kind of stuff. And I think that just to kind of round out that topic, if the key for where you place that money, right, is that it's earned upon receipt. If they give you a small amount, but you're going to bill against it, that still goes in your trust account. But if it's a flat fee that's deemed earned upon receipt, well, then that's the part that you put into your business
now that
account.
said, if you collect a flat fee of, let's say, $5,000, it goes in the trust account.
Right.
The court only made this exception for small flat fee advance fee payments of $2,000 or less. So a more significant flat fee paid in advance is of $5,000 goes into the trust account and gets moved over as work towards the completion of that case progresses.
Great. So my final question for you, because I know you've got work to do, and I don't want to keep you forever. If you could change one thing about how lawyers behave, what would it be?
That's interesting.
Kind of ambushed you with the questions this morning.
No, it's all good. To me, you're always going to have a certain percentage of lawyers who are, cutting corners, and maybe even cutting corners in areas where there are serious violations involving serious conflicts, mishandling client money. For me, the thing that just yearly becomes an issue for lawyers is communications and diligence, the small stuff. I will tell you that historically, you go back and you can go on our website and look at annual reports that we do for the past 20 years, and every single year I will guarantee you that the top of the list of complaints from clients is communications, Rule 1.4, and diligence, Rule 1.3. They sometimes switch places, but together they account for well over 50% of the complaints we receive. So in terms of resources that we use in our office, that is something that if we could just have lawyers communicate reasonably with their clients and not procrastinate, the discipline system would be a lot smaller in Missouri and I think throughout the country. So it's minor. It's not going to result in most cases in a suspension or disbarment, but nevertheless uses a lot of our resources trying to deal with those lawyers who simply are engaged in law practice management issues. The serious stuff is always going to be there. And in fact, we've seen somewhat of a decline in terms of these overdraft reports we get from banks. I think lawyers are understanding that that trust account is sacrosanct, and they have to be very careful. We do a lot of education in that area, so we're seeing somewhat of a reduction in terms of trust account violations. But these minor things, it just upsets the clients. If a client hires you as a lawyer, they want you to communicate with them, and they want you to do their job. They want to be treated like they are your only client, even though you may have hundreds of clients. And the good lawyers are the ones who are able to, the effective lawyers are the ones who are able to give that treatment to the client, even though they have hundreds of other clients that they're handling as well.
Yeah, I can hear some lawyers listening to this now, like the two people who might listen to an ethics podcast. I can hear people yelling sort of to themselves right now saying, well, you know what? I have so much to do. I have so much going on. I'm stretched so thin and I don't have as much help as I possibly, as I really need. I can't contact everybody. I can't communicate as much as I want to. And I wish I had some answer to that. One day we're going to have the answer to that for lawyers, because I get the impression that a significant number of people who don't communicate with their client don't do it purposefully. They don't have the time because of the pressures and the demands of the practice.
I think that's right. And I think, if anything, the internet and cell phones has actually exacerbated the issue.
Yeah.
Lawyers are thinking, oh, this is going to be great. I can give the client my cell phone number, and it's going to make it easier for them to text me and to call me. And what it's actually done is it's created more complaints, because the client who texts their lawyer at 11 o'clock in the evening is going to want a response by 7 in the morning, and it's like, and they'll file a complaint 24 hours later. I mean, the point is that, I know what you tell lawyers, and I tell lawyers the same thing, is create some boundaries for communication. I mean, frankly, it'll help you communicate with your clients if you tell them, look, it's going to take me maybe 24 hours, maybe 48 hours, maybe a week to get back to you because I might be in trial. Create expectations in the representation agreements, and the clients will understand that. Don't be afraid that they're going to go to a different lawyer. But, create boundaries, and it will cut down on communication issues.
Yeah. Setting the expectations is such, and we've talked about this when we've worked together on programs,
Right.
Setting the expectations from the outset is so important. And I think a lot of lawyers don't do that because they think, oh, no one's going to listen. Well, you know what? If 10%, 20%, 30% of your clients honor those expectations, that's a significant number of people who are going to make life easier for you, and it's better than no improvement.
Exactly.
So, well, thank you very much, Alan. I really appreciate your time.
Anytime, Stuart.
I'm gonna end it right now, and we're gonna keep our fingers crossed that my first time doing this actually worked out okay. Thanks,
Anytime.
Alan.
Thank you.